I'm sorry about that.
That's okay, Judge. Good morning.
Hey, good morning. How are you?
I'm fantastic, Judge. Thanks for asking. How are you?
I'm okay for an old guy. You want to start your time?
Yes, Judge, I'd like to reserve 3 minutes for rebuttal, please.
You got it.
Thank you, Judge. And may it please the court.
Yes.
My name is Jason Downs. I represent Mr. McKinnon in this case. He's the appellant. Uh, brief recitation of the facts. Mr. McKinnon was convicted by a jury of possession of a firearm by a convicted felon. He was sentenced to 10 years in prison, followed by 2 years community control and 3 years of probation. The issues that we've raised on appeal are as follows. Issue one, the trial court erred in ordering that a key witness was unavailable at trial through the forfeiture by wrongdoing act. And issue two, the trial court erred in its explanation to the jury regarding the unavailability of that witness. The facts are odd, to say the least, Judge. First and foremost,
So the witness feared for her life because her house was shot up. Is that right?
That's correct, Judge. And that's as part of the facts here. So there's one eyewitness to the alleged offense, Miss Carrie Riley. She showed up at court on the day of trial and said she was scared to testify. The judge inquired, and she made several allegations, Judge. First, she alleged that her house was recently shot up after she had received a subpoena to appear at this trial. She later testified that she was unable to specifically link this case to that shooting at her house, but she did say that there was a police investigation ongoing. The court,
Miss Riley was also confronted a couple days before trial. Is that right?
That's correct, Judge. That's one of her other allegations, was that the trial counsel, Mr. Lipy, had shown up at her house 2 days prior to trial and attempted to bribe her with $110 to not testify. During the court's I apologize. Go ahead.
No, go ahead. I think I just said right. Just
Okay.
acknowledging that we're on the same train here.
Thank you, Judge. During the court's inquiry, Mr. Lipy denied trying to bribe Miss Riley. He stated that he was trying to explain to her what a waiver of prosecution was. He denied any wrongdoing. There was no evidence that tied Mr. Lipsy's actions or alleged actions to Mr. McKinnon, or that they were done on Mr. McKinnon's behest or on his behalf. Ms. Riley testified that the incident was captured on her doorbell camera, but the judge never saw that video and never asked to see that video. Mr. Lipy tried to introduce contradictory evidence with his cell phone record showing that Ms. Riley had called him, but the judge refused to consider that evidence. Ms. Riley also alleged that she heard. I apologize. Go ahead.
I think that was an extraneous voice. You can proceed.
Thanks, Judge. Miss Riley also testified that she heard through the grapevine that Mr. McKinnon's siblings were going to attempt to reach out to her to also bribe her. But she did not testify that ever actually happened. She did not provide any corroborating information as to where she heard the rumors. She didn't disclose the source. There was no way for the judge to check the veracity of those statements. So based on that, the court found that Miss Riley was wrongfully approached or intimidated, and so the court found that she did not have to testify. She was excused, and the judge found that under Florida Statute 90.804 subsection 2F, as in Frank, and that's essentially the hearsay exception if the defendant wrongfully caused the declarant's unavailability at trial. So
Let me ask you, can I ask you a question? What is the burden of proof for the judge to make that finding? Is it reasonable doubt? Is it substantial? Is it greater weight?
It's competent substantial evidence, to my understanding, Judge. And
it's a judgment call if there's facts to support the judge's ruling. Is that true?
That's correct, Judge. And my argument is that the facts did not support the judge's ruling.
I get it. Okay, thank you.
Thank you, Judge. Now, under that statute,
So basically, we've got 3 or 4 things that they're pointing to. You've got the house being shot up, the attempted bribe, the rumors of other bribes, and the defense attorney approaching the witness a couple days before trial. So taking all this together, witness Riley says, "Look, I'm fearful of these people. I don't want anything to do with this. I'm not going to testify. Do with it what you will." Is that the gist of it?
That's the gist of it, Judge.
Okay.
And the issue that we take with this, Judge, and thank you very much for the clarification there. The issue that we take here is that the judge didn't require the state to meet its burden by providing any kind of evidence to support Miss Riley's claims. The judge didn't verify that there was a police investigation in any way, shape, or form. The judge didn't ask to see the doorbell camera that Miss Riley claimed that she had.
Wait, stop, Mr. Downs. The judge, what we're talking about here is the findings that the judge made, right? And she
correct.
put Miss Riley under oath
She did.
before she interrogated her. So, and she had some questions about the credibility of your trial counsel.
Yes, Judge.
And so at the end of it, the state didn't have a whole lot to do with this. Miss Riley told her story. The judge listened to Mr. Lipsy's story, and she resolved the credibility pieces of that in favor of what Miss Riley had to say. You agree with that?
I don't agree, Judge. Respectfully, I don't agree. The state is the one that brought this matter to the judge's attention because Miss Riley approached the state in the hallway outside of the courtroom. So the state brought this witness in. The state made the allegations and put her on the stand to raise this issue with the judge. And the state did make argument as to why Miss Riley should be considered unavailability through the forfeiture by wrongdoing statute. So I would argue, Judge, that the state was involved in this. They did make arguments. They did inquire along with the judge and the state.
But what else? You're sort of suggesting that the judge had a duty to independently verify the subjects that Miss Riley testified to, i.e. the existence of an investigation, which she would have known about since she was the victim in that. And I'm not sure that the state had to do all that. The judge had resolved the credibility. If she didn't believe Miss Riley, that would be the end of it. But she did.
I see your point, Judge. My point would be, Judge, that the state was prepared for this because they already had recorded phone calls between Mr. Lipsy and his client from the jail to use as supporting evidence. So the state, somehow the state was already aware that this was probably going to happen, and they'd already done an independent investigation. So they had some kind of supporting evidence when they showed up. And essentially what they introduced to the judge was a jail recording between counsel and his client, which should have been confidential, but regardless, the judge allowed it in. And in that conversation, Mr. Lipsy allegedly said to his client that the witness is not going to appear at trial. So the state had done some kind of digging and some kind of investigation, and that's the evidence that they showed up to court with. Again, they didn't show up with any police reports verifying that there was actually a shooting at the house. They didn't show any kind of investigative reports or call any kind of police officers to say that they suspect that Mr. McKinney was somehow involved in this while he was incarcerated. So the state didn't meet its burden. And so my argument, Judge, is that because the state didn't meet its burden in showing competent substantial evidence, that the judge erroneously ruled based on allegations that were not supported with facts. And by doing that, Judge, the court committed a fundamental error by not allowing Mr. McKinney or his counsel, Mr. Lipsy, to cross-examine the state's only eyewitness to the alleged incident. So what we're left with here is a trial that moved forward showing only the body cam footage of Miss Riley's statements to police and the police investigation after they had arrived on scene. And I will note that Mr. McKinney was not armed and he was immediately seized when he arrived on scene. And this is going to be prior to the statements that were made by Miss Riley to the police. So that out of court hearsay went unchecked at trial. The only other witness that the state called against Mr. McKinney was Mr. McKinney's uncle. And I apologize, I'm probably going to mispronounce his name, but it's Sodom McKinney. I believe it's spelled S-O-D-O-M. I'm going to refer to him as Sodom instead of Mr. McKinney, so there's no confusion. But Sodom essentially testified that he didn't hear any gunshots. He arrived after that allegedly happened. He did see the defendant, Mr. McKinney, with something in his hand, but he could not identify what it was or if it was a weapon because it was dark, he was behind a fence, and he was at least 150 feet away. So the state was able to proceed to trial with only the out-of-court statements by the only eyewitness, Miss Riley, and defense was not able to cross-examine her or to call her credibility into question in any way. So essentially, this left the government with a drastically reduced burden proceeding to trial. And that's the crux of issue one here, is that because there wasn't competent substantial evidence to support these claims, the judge should have never ruled that Miss Riley was unavailable due to Mr. McKinney's wrongdoing. And I'll rely on the case law that's in our briefs that support this argument and support the fact that this is a fundamental error. As to issue two, and I apologize, I can't see a clock on my screen. Can somebody give me a time? Okay, I don't hear anybody, so I'm not sure how much time I have left for my initial argument. But as to issue two, the jury, once they began deliberations, they sent a question to the judge. They wanted to know why Miss Riley wasn't there in person to testify. And the parties agreed to instructions that the judge provided. And it essentially began with witness Carrie Riley was exempted by a ruling of the court from testifying in this case. So our argument on issue two is simply that instruction in and of itself infers that there's some wrongdoing. It places Mr. McKinney in a negative light as far as the jury is concerned. And
that instruction was stipulated to by defense counsel, correct?
It was, Judge. It was stipulated to, and because this is a fundamental error, our argument is that there didn't need to be an objection, because a fundamental error can be raised at any time, even without a proper objection during the trial. And I apologize. I thought I heard somebody start to talk. Okay. So, again, Mr. Lipsy not only failed to object, and we're all aware that counsel's failure to object, his involvement in the allegations that were made, which essentially drastically affected his client in a negative light. And I understand that all these things are usually things that would be brought up in a post-conviction motion. However, because there was fundamental error here, I believe that direct appeal is the proper mechanism. In Moore v. State, the court held that failure to object cannot waive a fundamental error. And because this is a fundamental error, because again, the state was allowed to put on a case without being checked, they're able to put on the out of court hearsay testimony of the only eyewitness in the alleged offense. That essentially was a harmful error that was fundamental in its nature. And I would, if there are no questions, I'd reserve the rest of my time for rebuttal.
You have 6 minutes left of your 20 minutes. You can go a couple more minutes if you want to only argue for 3 on rebuttal, or you can save up to 5 minutes for rebuttal.
Judge, I'll go for another minute and I'll save the rest.
All right. Go ahead.
Judge, I would just point to Joseph v. State. That's 250 Southern 3rd, 113 at page 120. This is a Florida 4th DCA case from 2018. And that court held that the forfeiture by wrongdoing exceptions, for it to apply, the defendant must have engaged in conduct designed to prevent the witness from testifying. And later in its opinion at page 121, in that case, the court said, it would seem that the evidence must at least show that the appellant knew of a plan by one or more persons to engage in conduct or facilitate conduct that would cause the victim to be unavailable for trial. Judge, there was no evidence here that Mr. McKinney knew of any plan, that he participated in any plan, or that he encouraged any plan. So just based on that case alone, I would argue that the judge committed an error by finding Ms. Riley unavailable for trial. And thank you very much. If there are no further questions, I will reserve the rest of my time.
All right, that's going to give you a full 5 minutes.
Thank you, Judge.
Ms. Ramirez, you're next.
Good morning, Your Honors. May it please the court. Marina Ramirez on behalf of the state of Florida, Appellate. It is the state's position that appellant did not properly preserve either issue. In fact, neither of these issues were really before the trial court, and we should not be before this court.
Well, he's claiming fundamental error. which
Well-
precludes preservation.
But he did not argue as to issue one. He did not argue fundamental error on his initial brief, which makes him procedurally barred from arguing it and bringing it for the first time on his reply. As to the stipulated jury instruction, we also believe that that was waived, that should also not be before this court. But if this court would find that it was preserved, then appellant was charged with a single count of a convicted felon in possession of a firearm. The fact that he's a convicted felon is not in dispute. Yet appellant continuously refers to Ms. Carrie Riley as his accuser, which is clearly inaccurate based on the charge. Appellant also refers to Ms. Riley as a key witness, but he did not depose her nor subpoena her to testify on his behalf. She was the state's witness. And it was on that morning that the state found out what had happened. There was no investigation by the state. There was no recordings of this jail calls. They had just been monitoring the appellant and had heard him say, "The witness will not testify." Those were his words. "The witness will not testify." And that he was telling that to his trial counsel, who then 2 days before the trial used the guise of a waiver of prosecution, which would have been completely unnecessary and meritless. There was no need for a waiver of prosecution for this charge, to get to where she was. She was hiding out at her father's house. So then he found out she was there and tried to bribe her. That is when we found out the first time. And also, I would like to clarify that the burden for the trial court to determine her unavailability under section 90.804F is preponderance of the evidence. And as the court has already mentioned, she was very thorough in questioning this witness as to what had happened and what made her believe that why she was in such fear.
But this individual was not required to seek a explanation of what a waiver of prosecution was. That was Mr. McKinnon's testimony, correct?
Mr. McKinnon's trial counsel used that as an excuse to try to get to the witness 2 days before trial.
But she didn't solicit anyone to explain something to her. Like
No,
what a waiver
she did not.
is.
Absolutely not. She actually, looking at the record, she had actually already signed one, which was why the only charge here is convicted felon in a possession of a firearm. This isn't assault and battery. This isn't, attempted murder or any of that. It's just he's a convicted felon with a firearm. And I'd like to also differentiate the case specifically that Mr. Downs is referring to, Joseph. He cited Joseph and Mortimer in support that the trial court committed error. But this case is different because in Joseph, 2 recorded statements by the victim were improperly introduced at trial. And in Mortimer, it was the unavailable witness's testimony from a co-defendant's bond hearing. And in both those cases, the statements were clearly testimonial and hearsay because they were offered in evidence to prove the truth of the matter asserted. But here, we need to focus on what statements were actually introduced. And they were not testimonial. They were not hearsay. They were admissible as excited utterances. And the state argued that to the court because they were introduced through Officer Harris's body cam video and took upon his arrival at the scene. He was the first to arrive at the scene. So there was also no confrontation clause violation, which is really the only argument that Mr. McKinnon's trial counsel made before the trial court. They were not testimonial. The U.S. Supreme Court has defined testimonial statements as those made at a preliminary hearing, before a grand jury, at a formal trial, or in police interrogations. Here, Ms. Riley was warning the officers upon their arrival because appellant was firing a gun, which was a substantial threat to them and the public. And that the U.S. Supreme Court has held that they are not testimonial and they do not violate appellant's Sixth Amendment rights. Okay. The only other statement that could be heard by Ms. Riley was admitted through the uncle's testimony. And it was that my nephew was racing hell, shooting, and he pointed at me, quote unquote. It was not introduced for the truth of the matter asserted, but to explain its effect on the listener as to why he went over there immediately that night and called 911 when he saw appellant acting belligerently and erratically, as you can see in the body cam videos. That is why they had to detain him right away, because of the way he was acting. Therefore, it was not hearsay, and there was no error in admitting this evidence. The other error that Mr. Downs claims all of a sudden for the first time in his reply, which is procedurally barred, is the sufficiency of the evidence. He's now claiming that the only evidence to convict Mr. McKinnon was her testimony, but that is totally incorrect. The physical evidence was clear and damning. Appellant's DNA was found in both the firearm and its magazine, and the matching shell casing was found in the front yard. All of that proved that appellant's possession of the firearm, and that was the only thing left for the jury to decide. His uncle also provided testimony. Of course, he stayed away. He stayed 150 feet away, and if you can see from the videos, it was pitch black, so it was really hard for him to see what specifically appellant had in his hands. But as soon as the uncle went to call 911, appellant ran inside the house, and when he came back out, he didn't have that object in his hand. And then the firearm was found inside the house, underneath a mattress in a bedroom that had a letter addressed to the appellant next to the bed. That is all competent and sufficient evidence that proved appellant's guilt of being a convicted felon in possession of a firearm.
And can I ask you one more question? It seems that you're arguing facts that went to the jury, not to admissibility. So if the evidence is, the argument's to weight, not admissibility, he's going to be on the other side of the argument, but you get to let the jury decide what to believe and what not to believe, such as, was he holding that, was that gun an object? Was he holding it? Did he ditch it in the house, et cetera, et cetera? That's all weight versus admissibility argument. Is that true? Am I missing something?
No, but what I would argue is that it was not hearsay. That even if the trial court had abused its discretion, which we do not believe the court abused its discretion in finding in preponderance of the evidence that there was wrongdoing on the appellant and his trial counsel that made her fear for her life to the point where she refused to testify. That was up to the trial court to determine the credibility and weighing of the evidence as the fact finder. And there was no abuse of discretion here. But even if, I just want to differentiate and to point out the actual testimony that was heard, that was introduced at trial, was actually not hearsay and was already admissible. That is what I wanted to point out to the court. And I also wanted to point out to the court that the trial counsel, the defense trial counsel, admitted too that he went to see her on behalf of Mr. McKinnon. That is also on the record. When the trial court was asking him, why would you even be asking her for a waiver of prosecution? Because obviously that didn't make sense. And he denied that it was to basically convince her not to testify and also bribe her with $110. He led her to believe that signing that piece of paper would get her off the hook so she wouldn't have to deal with this anymore. So all of this and the fact that his explanation also as to when her house was shut up in July when she was subpoenaed to testify in this case, in this trial. That had never happened before. The trial counsel's explanation to that was, well, Mr. McKinnon has a right to access the computer system to know who's being subpoenaed to testify against him. He basically admitted that yes, he knew exactly who was getting subpoenaed and when. The timing of that is not as speculative as they are trying to argue now. And the trial court could see right through that. This case boils down to a woman who was peacefully in her home when appellant decided to create a loud disturbance and shoot his gun while angrily and belligerently pacing back and forth in front of his house. And then shortly after she was subpoenaed to testify, her house got shut up, something that had never happened before. And then she's approached at work with people telling her that appellant's brothers want to pay her not to testify. And then 2 days before the trial, while she's hiding out at her father's house, she's contacted by appellant's counsel under the guise of having her sign that meaningless waiver of prosecution. But it was actually to offer her money so that she would not testify. And now she sees them that morning. She sees them all in the courthouse, and she is terrified. And it cannot be said that no reasonable court would find that she was in fear of her life, thus unavailable, due to appellant's wrongdoing and his counsel's wrongdoing. At the very least, appellant's acquiescence was revealed by what he said to that man, to his attorney, several times in the jail calls. The witness will not testify. The witness will not testify. That's an order. That's a strong request to the man who then bribed the witness not to testify and who admitted to go in there on his behalf. I would argue the credibility determination and weighing of the evidence is left to the trial court as the fact finder, and it cannot be said that no reasonable court would agree with this trial court's decision. Thus, the trial court did not abuse its discretion. Ms. Riley's statements were properly admitted because they were not hearsay, but as excited utterances to warn the police of an ongoing emergency that threatened them and the public, and to explain why the uncle arrived at the scene immediately after Ms. Riley called him. There was no error, harmful nor fundamental. The physical evidence was damning. And if the court has no further questions, the state will rest on its brief and respectfully request this court to affirm appellant's conviction and sentence.
Thank you. Mr. Downs, you asked for 5 minutes for rebuttal. You have your 5 minutes beginning now.
Thank you, Judge, and thank you, Ms. Ramirez. Judge, as to the argument that state began with, that we did not preserve, or that defense counsel did not preserve issue 1, in the state's own answer brief on page 5, the state says appellant's counsel objected, stating, "I can't cross-examine this witness," but the court ended further discussion on this matter. So, and this is in our brief, but I would again argue that that issue was preserved. If the court doesn't find that this was a fundamental error, it was still preserved because Mr. Lipsy did object. He did state, he argued with the judge and said, "I can't cross-examine this witness. I have cross-examination prepared for this witness." This would be considered a timely objection under Figueroa Sanabria versus State. That's 366 Southern 3rd 1035 at page 1049, Florida Supreme Court 2023. It would be a timely objection because it provided grounds for the objection that were sufficiently precise and fairly appraised the court of the relief sought, and the relief sought being the cross-examination questions. But again, we would argue that because it was a fundamental error, that it's a moot issue. Judge, as far as the Mr. Lipsy going to Miss Riley's house, or her father's house, wherever it was that she was, the record will show that she invited him there. She invited Mr. Lipsy because apparently she was confused. She thought that he represented the state of Florida. So she disclosed the address and invited him to the house. As far as the statements that were made on the body cam footage, Judge, I would argue that those did go to prove the matter asserted, because again, that's the only statement, or those are the only statements that show the crime actually occurred. The state cited in its brief to Davis. It's a U.S. Supreme Court case, and they cited it as 547 U.S. at page 822. And that's an important case here, Judge, because there the Supreme Court said where the primary purpose of the interrogation is to enable police assistance to meet an ongoing emergency, that's when they find that those statements aren't testimonial. Here, the emergency was over. Mr. McKinnon was seized immediately upon police arrival, had no weapon in his physical possession. So there was no longer an ongoing emergency. So therefore, her statements were testimonial because she gave a recounting of what she alleged occurred prior to the police arrival, which went to the elements of the crime charged. And again, that was Davis at page 822. The Supreme Court also decided, made an opinion in a case called Pettit, which the state cited in its answer brief. The Pettit case provided guidance as to whether there was an emergency ongoing. They gave five things to look at. Number one, whether an armed assailant poses a substantial threat to the public at large. Number two, the type of weapon. Number three, the severity of the victim's injuries. Number four, the formality of the interrogation. And number five, the involved parties' statements and actions. So here there was no longer an armed assailant, so there was no threat to the public at large. The victim had no injuries. The interrogation involved asking Miss Riley what happened, and Miss Riley's statements went to the elements of the charged crime. So again, I would argue that her statements were absolutely testimonial. There was no ongoing emergency, which would exclude it under both of those cases that the state relied upon in its answer brief. As to the DNA that was found on the weapon, we all know just from common sense that doesn't prove that Mr. McKinnon possessed that firearm while he was a convicted felon. It does prove that at some point he likely did possess that weapon, or at least had some kind of physical contact or close proximity to it with transferred DNA, which you know I didn't plan on getting into. But the DNA evidence in and of itself wouldn't be enough to convict him beyond a reasonable doubt that he did possess a firearm while he was a convicted felon. And that nexus is important. That nexus is something that that counsel should have argued at trial.
You've got about a minute and a half left.
Thank you very much, Judge. Again, Judge, the body cam of Miss Riley saying that she saw Mr. McKinnon fire the weapon that should have been introduced. Judge, I would just respectfully request that the court review this again as an abuse of discretion, and it was a fundamental error on both parts, both to exclude Miss Riley without supporting evidence, substantial confidential or confident evidence to show that the statements she were making were supported by facts and evidence. And without that, it was an error to exclude her testimony. Again, I have referred to her as a key witness because she was the only eyewitness.
You want to do a summary statement because your time has just expired.
Judge, I would just respectfully request that the court reverse the conviction and remand for a new trial because of the court's numerous fundamental errors. And I thank you very much for listening to us today. And again, thank you, Ms. Ramirez and State. Nothing further, Judge.
All right. Thank you both. Well done. We'll excuse this case. We'll move on to the next case.
Thank you. Everybody have a wonderful day.